So, Professor Gilbert, we've gone over the facts of these cases. The Supreme Court has struck down this law prohibiting the defense of extreme intoxication. What can you tell me about that Supreme Court decision?
Sure. So all three of these accused wanted to be able to argue that they had become so extremely intoxicated that they were essentially automatons, that they had absolutely no control over their movements or their actions. But the criminal code prevented them from making that argument because that automatism arose from their own self-induced conduct of getting extremely intoxicated. And so it was a particular provision of the criminal code that prohibited defendants from being able to rely on extreme intoxication when it was their own fault that they got intoxicated. And that was what the Supreme Court struck down. And they struck it down because they said that it is a basic principle of criminal law, and that is protected by Section 7 of the Charter, that you cannot be convicted of a crime unless you acted voluntarily, and that this provision essentially took that criminal law principle out of the mix, and that was a violation of the Charter. And so what that left us with then is this what we're going to talk about today, this gap of from now on after that decision, without further government action, accused would be able to raise the fact that they had put themselves into an extremely intoxicated state and shouldn't be held responsible for what happened after that.
So, Professor Frock, anything that you want to add about the Supreme Court's decision before we turn to the legislative response?
Right. Well, I think it's important, and I don't want to get too insider baseball here, but it's important to know that extreme intoxication in this defense is arising in what the judges call a general intent offense. So these are offenses where a very specific kind of intent, like the intent to kill someone, which is a murder, of course, is a specific intent. It's offenses like assault, aggravated assault, sexual assault. And before the court's ruling in Davio in 1994, it was the case that intoxication of any kind wasn't a defense under the common law to general intent offenses. Significant intoxication, of course, is a defense to the specific intent, but then if you're acquitted of murder, you can be convicted of manslaughter. If you're not, if you are successful in an extreme intoxication defense under the common law for these violent offenses, then you're acquitted. So that's important to note that there is that distinction there.
And Davio, the case you referenced, is of course a case, I believe, from the 90s that caused a legislative response by the government of the day then that introduced this prohibition on self-induced intoxication, because in that case, it involved an individual who had consumed a huge quantity of alcohol and then committed extremely violent assaults and sexual assault on an elderly woman. Before we turn to the legislative response, though, I'm interested in Davio was a case that involved alcohol. These three cases all involved either pharmaceuticals or psilocybin mushrooms. Would alcohol rise to the threshold nowadays in a case like this? If the case of Sullivan, Chan, and Brown had only involved alcohol, could that have got these individuals to the automaton level, or is alcohol kind of not enough? Professor Gilbert.
So the court in these three decisions was really clear that it thought it was very unlikely that alcohol use alone could put you into an automatistic state. And they cited some of the evidence that had been presented to Parliament about that, about how alcohol is more of a depressant that would leave you unconscious, as opposed to something that would cause you to act out violently once you had reached this extreme intoxication kind of level. Automatism is a term of art, and it requires scientific medical evidence, to be presented to court to verify that you had indeed got to the point of being an automaton. It isn't just being very intoxicated. It is actually sort of a step above that. It's an extra state that you have to be put into. And so so far, at least the expert evidence that we've been hearing suggests that alcohol alone would be unlikely to be able to put you into an automatistic state. But it would all be up to the evidence of the day and who you could find as an expert.
Professor Frock, 10
Yeah.
seconds. Anything to add to that?
Well, I just want to clarify, Brown ingested a significant amount of alcohol as well. Davio ingested alcohol, and
Carrie,
he was found...
I'm so sorry. We've got to go to break, but I'll let you finish that in the next segment.
Sure.